In the mains of 2024, a question was asked on peaceful settlement of international disputes under international law concerning friendly relations and cooperation among member states. This was a 20 marks question. So of course we need to answer in detail about the various mechanisms of peaceful settlement of international disputes. And here we need to write particularly about Article 33 of the UN Charter. Other than this, you should also mention two important points. One is about Article 1 Clause 1 and Article 2 Clause 3 of the UN Charter, which particularly mentions that various international disputes should be settled through peaceful means, as the whole purpose of United Nations is to ensure global peace. And with respect to the settlement of disputes, international disputes through peaceful mechanisms, the role of UNSC has also been envisaged. So this is one thing which you should mention. And the second is that these various mechanisms such as arbitration, conciliation, fact-finding inquiry, etc. were also mentioned in the Hague Conference or the Hague Peace Conference of 1899 and the Geneva Conference or Geneva Protocol of 1924 with respect to peaceful settlement of international disputes. Now coming to Article 33 of the UN Charter under Chapter 6 of UN Charter. First and foremost, it mentions about various aspects or various ways of settlement of international disputes in a peaceful ways, but as such there is no hierarchy. So it's upon the disputing states or the disputing countries to choose any one of those peaceful settlement of disputes. Another important point is that the element of good offices is not mentioned under Article 33 of the UN Charter. So these are the two important points which you should mention. Other than this, talking about negotiation, so two countries, disputing sides directly interact with each other without involvement of a third party. In good offices, third party is involved but not directly involved. And this is the difference between good offices and mediation. In mediation, the third side is directly involved, whereas in good offices, they are not directly involved. Examples of use of good offices: Secretary General also offer their good offices to settle international disputes. Now, fact-finding inquiry. The idea is to find about the correct information upon which the disputing sides are fighting or they are having their disputes. So the idea is just to give them the correct information by a neutral commission. Coming to conciliation. Now, conciliation involves elements of mediation and also fact-finding inquiry. So at times also referred as conciliation commission. So these are extrajudicial methods. That is, these are not binding. And then comes the judicial methods, including use of ICJ and arbitration. Other than this, there is also use of regional organization under Article 52 of the UN Charter.